This is the Content Marketing Podcast, episode number 149, How to Protect Your Content, an interview with media attorney Travis Crabtree. Hello and welcome to the Content Marketing Podcast. This is the show where we help you attract and retain business through the power of quality content. I'm your host, Rachel Parker of Resonance Content Marketing, and today is November 19th, 2015. Hello, or as we say in Texas, howdy, and thank you for joining us for today's episode of the Content Marketing Podcast. Just a reminder, we are live on iTunes and on Stitcher, and soon to be live on Google Play. That podcast capability is coming up very soon. If you are listening to this episode on the blog, you can click on over and subscribe. And of course, if you use a different app for your podcast listening pleasure, we also have an RSS feed, and I will provide that link in the blog post. Also, if you'd like a daily dose of content marketing mojo, I invite you to follow us on Twitter at Resonance CONT. It's Resonance Content with the ENT lopped off. Would love to welcome you into our little Twitter community. Okay, this is my birthday week. My birthday was a couple of days ago, and I want to say thank you. Excuse me, to all my peeps who sent birthday wishes. And, some people don't like birthdays, but I dig them. I dig them. I really do. Who was it said, getting older is a privilege that is denied to many. And dude, there's cake. I mean, what's not to love? Also, I want to give a special shout out to Rebecca Thompson of the Virtual Cast Connection podcast. Rebecca was kind enough to have me as her guest last week to chat about content marketing, and we had a lovely time together. If you want to check out Rebecca's podcast, I will provide a link in the show notes for this episode. Do check it out. She does a great job. Last week we had a wonderful interview guest. Now, if you've been meaning to write a book and it just hasn't happened yet, last week's podcast was the episode for you. My friend Kevin Tumlinson joined us to talk about his latest book, The 30-Day Author, and he provides a bulletproof formula for getting that book cranked out in 30 days or possibly less. So if you happen to miss that episode, do check it out on iTunes or Stitcher or via the RSS feed. This week, we are changing tracks a little bit and talking about the legal side of content. Specifically, we are chatting with media attorney Travis Crabtree about how to legally protect your content and how to stay on the right side of the law when it comes to sharing content created by others. But first, it's time to check in with our news feed for this week's rundown of news you can use. When I put together these items for the news feed, I was run across a lot of information about advertising, about new advertising features and new analytics, and I never figured out why I just wasn't really excited about sharing all that. And I was having breakfast with my friend Shelley Roth earlier this week, and Shelley just nailed it. She has been a social media trainer for 8 years, believe it or not. She's been with it from the very beginning. And she said, people ask her to teach classes about Facebook advertising and LinkedIn advertising. And she said, I'm just not interested in teaching people how to spend money. And that's how I feel about it. I mean, there's nothing wrong with advertising, but here on this podcast, we're all about the content. So I prefer to focus on that area. But I thought that was an interesting point. I was like, yeah, Shelley, you nailed it. That's what I'm doing here. So that being said, Pinterest has a new feature that is not advertising related. They have a visual search tool. So users can now search on Pinterest for things they may not know the words for. And this is terrific news for retailers. So, for example, say a user is searching on Pinterest and she's looking for home decor ideas. And she finds a pin that has a lamp that she really, really likes, and she wants to see other similar lamps. I'm sorry, I've got a snoring beagle behind me. It's a rainy day in Houston. She just couldn't keep her eyes open. But anyway, say she finds a pin with a lamp that she really likes. What she's going to be able to do is zoom in on that lamp in the photo in the image, and then Pinterest will show her other pins like the object that she zoomed on. So in the blog post that Pinterest announced this feature on, they set up a little GIF that shows how it works, and they showed a scene with a lamp that was from, I don't know, Restoration Hardware or something. And they showed how the person would zoom in on that lamp, and then Pinterest would show them different pins with similar, in this case, black funnel-shaped lamps. So, very cool feature, especially, like I said, for retailers. If you are in home decor or fashion or other retail products, this can be a definite benefit. And it also highlights the importance of having good photography. You want to make sure that your photography on Pinterest is very clear so that you can tap into the benefits of this visual search function. Okay, also some news out of Periscope. They have announced a couple of new features. Number one, they have a new and improved global map. So if you go to Periscope on your phone or your mobile device, you will see a map that shows what's going on in the world of Periscope. Now, previously, this map only showed live events that were broadcasting at the moment that you check the map. But now it shows not only live events, but also replays from the past 24 hours that are accessible. So now when you go to the Periscope map, you will see a red dot for events that are currently live, and you'll see a blue dot for Periscopes that are now available on replay. So very cool feature from our friends at Periscope. Also, when you are watching those replays, you will now be able to skip ahead. So previously when you pulled up a replay, you would kind of have to watch the whole thing. But now you can actually skip ahead, which is handy, say, if you're watching a Periscope and have to hop off for a meeting or a conference call or something. You can now catch the replay and pick it up where you left off. So very much improved user experience over at Periscope. Okay, wow, no news out of Facebook this week. Go figure. For our content hit of the week, I have chosen a post on Social Media Examiner by Brittany Berger, and it's called 4 Tools to Build a Social Media Content Calendar. And the reason I chose this piece is, like it or not, 2015 is winding down and we are getting ready for 2016. So if 2016 is going to be the year that you get your social media content organized in an actual calendar, this is the post for you. And Brittany shows us how we can use tools like Google Sheets, Google Calendars, and other easy-to-use tools that can help you create a really effective calendar that will keep you and your team on schedule and on task. So highly recommended, and I will provide a link in the blog post for this episode. Okay, that's it for this week's update. If you stumble across something you think might be of interest to your fellow content marketers, please shoot it on over to us so that we can share. Now it's time for this week's Spotlight segment, How to Protect Your Content, an interview with media attorney Travis Crabtree. Travis Crabtree brings a unique perspective to his internet law and commercial litigation practice. Travis graduated from the University of Missouri School of Journalism and spent several years in television news before embarking on a law career. Travis explores the emerging legal issues and trends for the internet, marketing, technology, intellectual property, and online media on his blog, emedialaw.com. His internet law practice focuses on media communications, online defamation, privacy, domain name disputes, policy and governmental compliance, software audits, copyrights and trademarks, and related transactional documents for startups and technology companies, which makes it a wonder that he had time to chat with us today. Today, he is indeed kind enough to join us for a chat about how to protect your own content from a legal standpoint and how to stay on the right side of the law when sharing content created by others. Without further ado, here's my interview with attorney Travis Crabtree. Hey, Travis, welcome to the podcast.
Oh, my pleasure.
Absolutely. So I just gave your official introduction, so would you take a couple of minutes to tell us on a little more personal level who you are and what you do?
Sure. I describe it as an internet marketing and media practice. I was naive enough to get out of law school and think that the Houston Chronicle and the New York Times would hire me fresh out of school. But, they had lawyers that had gray hair and lots of experience. And so after just doing commercial litigation, whatever kind of came in the door for about 6 years, I started getting involved in the online media space. And it's been an awesome journey ever since.
Mm-hmm. Awesome. So Travis, the reason that I wanted to chat with you today is, content marketing has just exploded over the last few years. There's so much content being created, nobody can even count it to get those numbers together. And of course, when there's so much content being created, the issue of intellectual property comes up. So I'm going to be true to my roots and harken back to my 8th grade Catholic school composition class and start by defining our terms. So when we say intellectual property, can you give us a quick definition of what that is?
Sure. There's, the tangible property, which is your desk, your computer, your pens and pencils, if you're manufacturing something, what you manufacture. Mm-hmm. Then there's what's referred to as intangible property, things that you can't really put your hands on. Mm-hmm. And one of those types of intangible property is intellectual property. And that's usually what we call copyrights and trademarks. Patent law is involved there too, but I know enough about patent law to be dangerous and know enough to refer it to my colleagues that do that full time. Mm-hmm. So with regard to copyright and trademark, it's really the expression of the idea that you come up with, that you invest your intellectual capabilities to create something. Mm-hmm. And given that you have taken the time and effort to create it, the law says you're entitled to some protections. And copyrights and patents are both actually listed in the Constitution. So it's not as if this is a new thing, but it is listed as something that the founders of this country thought was important enough to protect and to give people credit and to encourage them to continue to create so that they can, by giving them these protections, they can make money and therefore be encouraged to keep going.
Mm-hmm. Yep, absolutely. Travis, you bring up a good point. This podcast is fortunate enough to have an international audience. So we are, of course, talking about the United States with respect to your expertise. But what about people who are, say in Australia creating content that might be read in anywhere from Dubai to Alaska to India?
Yeah, there's I wish I was smart enough to know all the copyright rules that would apply or trademarks that would apply internationally. I can tell you and speak well enough to know that most of the principles apply across various countries. There's some nuances that are different. There are various treaties between the nations that honor and respect the intellectual property from one country to another. There are also known to be certain countries that allow for more infringement and are a little bit looser about enforcement. But for the most part, the principles that we'll probably talk about during this podcast and that we'll cover apply universally. And, if you can get protection in the U.S. through treaties, you can usually get protections in most of the rest of the world.
Mm-hmm. Okay, great. Well, before I get to my specific questions, I just want to ask that as a media, internet, and marketing attorney, what questions are you hearing when people call you with questions? What kind of things are they asking about?
A lot of it has to do with some of the more basic issues. They want to use a video that somebody else created and put it on their blog, or they want to even take an image from that video in order to promote the video. And so the most common issue that comes up is, what can I use in my own work that is created by other people? And a lot of my job has to be deal with distilling myths. People think that because it's Google Images, they can take it and do what they want with it, and that's just not true.
Yep, absolutely. So I want to start by talking about how we can protect our own content. Now, I know I have on my website a little footer that says Copyright 2015 Resonance Content Marketing, and that's about as far as I go. So does that give me really any real protection?
So this is where we'll take a sort of a hyper focus on U.S. law. It doesn't. You don't need that little symbol. That's a old law and an old belief that's a little bit outdated. That it doesn't grant you any more protections than if you didn't have the little C with the circle around it. And so anytime you create something and you publish it for others to see, to the extent it is something that is within the purview of copyright, something that you've written, something that you have recorded, you are granted automatic copyright protections right then and there. Mm-hmm. And so you are protected. Now, the big publishing houses that have a lot of money will register the works. When Stephen King finishes a novel, he registers that work with the U.S. Copyright Office. The reason that they do that is by registering the copyright, you are given additional protections. And what that really relates to is if you had to sue someone, you're going to have to register the copyright. Mm-hmm. And registering is really not that big of a deal. But the additional benefit of registering your copyright, and there's certain timelines involved that in order to get these protections, you have to register it within a certain amount of time, a fairly short time frame after you publish it. Mm-hmm. But that would give you or allow you to recover attorney's fees if you sued someone. And probably more importantly, it allows you to get statutory penalties against the person who has infringed on your copyright. Mm-hmm. And so that's why, if you have the money and the time, it's usually best to register your copyrighted work, because otherwise you're going to have to prove actual damages. And I write a blog, and I don't register every single blog post. Mm-hmm. But just imagine if I had to come up with a theory on calculating my actual damages if somebody took too much of a blog post or flat out copied the entire blog post and put it on their site. I'd have a hard time proving that by their act of doing that, I suffered so much in damages, or the licensing value of that work is a certain amount. And in order to recover in court, that's what I would have to prove. Mm-hmm. If I were to register that copyrighted work, I would simply say, hey, there's a violation. I registered. I'm entitled to statutory penalties, which is between $750 on the low end and thousands of dollars on the high end per infringement. And so that's why people register their work, and that's the additional protection of registering the work. But people don't have to do that, and you own all of the copyright rights that an author has when they create the work itself and then publish it without registering it, without putting a little C with a circle around it.
Mm-hmm. Okay, great. So let me ask you a very basic question. And this is a very gray area, but what constitutes stealing content? So if someone copies and pastes, let's say 50% of a blog post, but gives me credit and links back to my original post, how on the scale, how bad is that?
Well, you're getting into the area of fair use. Mm-hmm. And so despite, this is another, it's almost like we're doing an episode of Mythbusters. Right. We don't own the register, we're trademarked to that. We're just using that as a point of reference.
That's right.
We're not violating anything. So the issue there is a fair use issue. And I've heard people tell me, well, as long as I use less than 10%, or as long as I don't use more than 3 paragraphs, I'm fine. Mm-hmm. Absolutely not. That is not the law. The law is, and this is, I guess it's a good thing because it keeps me employed, is very gray in this area. There is no bright line test. Mm-hmm. I can't sit here and tell your listeners only use 10% or only use this amount. Right. Because the 4 factors that the judges consider are the purpose of the use. In this case, if you are using somebody else's work and you're using an excerpt, they would look at the purpose and character of how you're doing that. Mm-hmm. They would look at the nature of the copyrighted work that you're taking it from, plus your own. They do look at one of the 4 factors is the amount of the taken portion, how much of it was been taken. And then they're also going to look at the effect of the potential market on what you've taken. Mm-hmm. The fact that you have put it into your blog post, does that mean the commercial market for that other work is going to be lessened? And so it's I know it sounds gray and a bunch of mealy legal talk, but the courts purposely don't put a bright line test on this. And obviously Congress passed the U.S. Copyright Act, and they haven't put a bright line test on this. So it's somewhat of an unsatisfying answer. And without without saying going into certain hypotheticals, we could use hypotheticals and kind of guess on what a court does. And usually, what I have to tell clients is, hey, I can't guarantee you that you're not going to get into trouble or get a cease and desist letter or even be sued. But my opinion is, in this case, it's fair use, so you should be okay. Mm-hmm. And that's about the best lawyers can do on the front end.
Mm-hmm. Mm-hmm. Okay, great. Now, Travis, we talked a little bit about the content that I produce on my blog, on my website. What if I go out to, say, Medium or Tumblr, or publish a full blog post as a Facebook note? Am I still entitled to the same protection?
Generally speaking, you are, and it really depends on the terms of service, that stuff that nobody ever reads, on what's on each one of those sites. And so usually what happens on most reputable sites is that you grant just the website itself. I'm going to use the term the platform. Mm-hmm. So Facebook is a platform, Twitter is a platform. So you grant Facebook the rights to publish your work on their platform, mm-hmm. and usually you grant the right for people to share that content, mm-hmm. As long as they're doing it within the platform. And so that's why retweets and sharing on Facebook are perfectly legal, because you have contractually allowed that to happen to your work. Mm-hmm. Most of those sites in the terms of service don't allow somebody to then just copy and paste whatever you put on Facebook and go to their own blog and copy and paste it there, mm-hmm. Because that's outside of the platform. Mm-hmm. So it really depends on the terms of service, right. Because that's a contractual agreement between you and the website where you're posting it as to what rights you retain and what rights they have, in addition to what rights do the users of those platforms have.
Mm-hmm. Yep, absolutely. It's funny you mentioned video a few minutes ago. I just learned about a new nefarious practice on Facebook called freebooting, where people download entire videos from YouTube and then go over to Facebook and upload it as their own. And that's wrong in so many ways.
Yeah, and the good news is, and maybe this is the segue into the Digital Millennium Copyright Act, is if you own the video, the Congress has passed this law to presumably make it easier for you to get those removed. Mm-hmm. And just because you put a video up on YouTube doesn't mean everybody can take it and do what they want with it. Mm-hmm. So you still own the rights, even though you put the video up on YouTube. And if somebody takes that video and places it somewhere else, then you can use the Digital Millennium Copyright Act to try to at least get it removed. And that's usually a very straightforward and easy process, especially with established platforms like Twitter and YouTube and Facebook, because they honor those requests. They have online forums for those requests, and it's pretty easy to take down those videos.
Mm-hmm. Mm-hmm. Okay, great. And would the same be true for audio? Sometimes I don't do this myself, but I'll hear a podcast end with copyright 2015 Billy Bob's podcast or whatever. Is that necessary in the same way that it's not really necessary on websites?
That's true. Saying something that is copyright, if it's a recording, all recordings are entitled to copyrights as soon as they are recorded and then published to someone. Mm-hmm. And so the minute you post this podcast up, you have a copyright in the contents of it, and people can't steal it. Mm-hmm. Yeah, the one reason some people put the copyright language in there is if you're going to use the statutory damage model, people say, hey, we gave everybody notice that they weren't allowed to use it. If you watch I'm a sports fan, so every sports game, there's the quick talking part about all the images are the rights of Major League Baseball, and you can't use them without their permission. Mm-hmm. So what they're doing is helping establish a request for a higher statutory penalty, because they say, hey, we put everybody on notice. We told them they couldn't use it without our permission, and yet they did it anyway. So, Judge, don't make it a $750 fine. Mm-hmm. Make it the $20,000, $50,000. I think the max is $75,000 fine that you can get, because we put them on notice and they ignored it anyway.
Mm-hmm. Mm-hmm. Okay. Interesting. Good advice. So, Travis, how can I keep a digital ear out for any possible misuse or less than kosher use of my content? Are there tools that I can use, or what's the best way to keep an eye out for that?
Yeah, that's a good question. I don't, as I've mentioned, I'm a blogger myself, and I don't use any tools out there. I know that there are some that are. I do know that photographers, you can search Google Images by searching an image, and so I know that they use some of those basic functions. And not to get too wonkish in policy on you, but that's one of the complaints about the Digital Millennium Copyright Act is that it puts the burden on the copyright holder to go find these infringing things and notify the websites on them. So that's what to the extent there's pushback on the DMCA, and there's some on it being abused by the copyright holders because they don't consider fair use, and websites automatically take stuff down even though it is a fair use. So that those are kind of the two issues involved, but they do put the burden on the copyright holders, and because I don't take advantage of those tools myself, I don't know the full extent of which ones are out there.
Of course, if something's so sensitive that it would really devastate you if someone stole it, it probably doesn't belong on your website in the first place.
Yeah, I mean that's true. And obviously, if you're Stephen King, you're putting that out, and that's all you do. But yeah, this gets into a really tricky issue when we talk about intellectual property rights. There's obviously copyrights that we've talked about, trademarks, and the difference between those is copyrights is the expression of an idea, and trademarks really is just your symbol, your catchphrase, your business name, things like that are really short and succinct. There's patents, which protects the process on how to do something. But the one that isn't subject to a statute is trade secrets. And so if something is really worthy of protection, then you would consider that a trade secret, because when you file stuff with the Copyright Office, you have to file a copy of it, and people can actually go to the Copyright Office and look at it. So that's why things like Coke's allegedly secret formula, which apparently you can find online now, or the Colonel's secret recipe for fried chicken, those are kind of the textbook trade secrets that people talk about when they try to distinguish between trade secrets and copyrights and patents.
Yep, absolutely. So Travis, if I happen to discover a case of my content just blatantly being stolen, like a blog post copied and pasted 100% on someone else's blog, what would be my first steps in pursuing recourse?
So that's where the Digital Millennium Copyright Act comes in, because it's really easy to use. And so what you would do is if your copyrighted work is being posted on, again, I'll use the term platform, such as Facebook or YouTube, then you can easily search Facebook, someone's infringed my copyright, and it'll take you to the page where you can literally put the URL where the infringing material is, show where you originally put it, and they're pretty good about taking that stuff down within 24 or 48 hours. So you can at least get it removed.
Yeah.
It's trickier, obviously, when it's on a private website that isn't a platform. And when I say platform, that would include things like Blogger and Blogspot and WordPress. They all have mechanisms in place that allow you to file it's called a takedown notice, a DMCA takedown notice. It's easy when it's there. When it's on their own private website, you have to do a little bit of digging. You can use the Whois database, which if you enter the domain name may or may not give you enough information, but you try to find out who the hosting service is. And so if you can find out who the hosting service is, you send that same DMCA takedown notice to the hosting service, and they'll take it down, because what the DMCA does is it protects the platforms that we've talked about and the hosting services from being liable for contributory infringement. Just imagine if YouTube had to pay or defend a lawsuit every time there was something copyrighted put up on their service. We wouldn't have YouTube, we wouldn't have Facebook. So Congress has built in the DMCA to give them these protections, and in order to be entitled to these protections, these websites honor takedown notices and remove the infringing material.
Okay, great. So Travis, I want to shift gears a little bit and go to the other side and talk about how we can we can stay on the right side of the law with respect to other people's content. So, just to start at the lowest possible level, if I go out on Twitter and say, "Hey, Travis Crabtree just wrote a great blog post about the Houston Astros data being stolen. You should go check it out," and give the link and tweet it, no problem with that, right?
Absolutely not, because you haven't taken, the expression of the idea. The expression of the idea is not the mere fact that I wrote something about a topic. Nobody can protect that. The expression of the idea that is subject to my protection and my rights is actually what I said in that blog post. And so you haven't taken any of that, and you're perfectly fine.
Okay, great. So you mentioned, visuals have just completely taken over. We've got Instagram and Pinterest and visuals taking over Facebook. And as you mentioned, a lot of people will just go to Google Images and pick something that looks pretty and put it on their website. So tell us why that's a bad idea.
It's the same basic concept that just like a novel or a story or a song is subject to copyright, photographs, even the most mundane photographs, generally are entitled to copyright protection. And that copyright protection belongs to whomever took the photograph. And so just because the picture ends up on Google Images does not mean that the photographer has given up his copyright rights to that image. And so if it's on there, I put personal pictures on my blog post when I can, just to avoid any challenge to the use of an image or having to use stock photos. But now my photos can be found on Google Images, and it doesn't mean that I've given anybody and everybody permission to use that image.
Yep, absolutely. So you mentioned the best way. So you think the best way is just to use our own images and just avoid that altogether?
It's either that or, but that's not doable. I mean, there's been many a time where I've written, quite frankly, a dry topic that a picture of my kids and me just doesn't make sense. And so, that's not a workable solution in all situations, obviously. But if you can, that's what I usually do. There are sites out there that allow for either subscription-based use of somewhat stock images. There are Creative Commons licensing issues. You just need to make sure when you use some of these services for the stock photos, they all have their own set of rules, and they're with slight nuances, they're different. And so, some of them say you can use this image for whatever purpose you want, whether it's educational or commercial. But you have to give attribution. And so you've got to make sure you follow that rule. There are some that say you can use this image for anything that's not commercial. Okay, well, now you got to make sure, and you are a lot like what I do. I don't necessarily consider my blog to be commercial. I consider it to be educational and informational. But obviously there's a commercial aspect of it because I want people to know that this is the area that I practice in and I care a lot about it and I write about these topics, which very similar to what you're doing. And so that's not always a clear line as to whether it's commercial or not. So you just have to be careful, and some of them are only for a limited time. And so if people don't go back and refresh their images, and so you just need to be careful. And that's true with the paid ones too. I've had many a time when website developer will grab an image and buy a license for that image, but the license is only valid for 2 years or something like that. And it just never gets refreshed. And next thing you know, it's 8 years later, and my client hands me a cease and desist letter from Getting Images saying, we want our money.
Yeah, absolutely. That reminds me of a story I heard recently. A woman had signed up with a stock photography service and wound up in the middle of a Getty lawsuit because the site she had licensed the photos from did not have the rights to the actual photos that they were licensing. So it's critical if you go the stock photo route to find a reputable source for those as well.
Yeah, that's right. In that situation, there is, copyright law is kind of known as what we call a strict liability statute. It doesn't matter that, oops, I didn't mean to or I didn't know. The courts are still going to hold you liable.
Sure.
I would imagine in that situation, to the extent there were statutory damages, it would be on the very low end of that if she was truly innocent and the judge or the jury believed her. But it's still, some risk and exposure that can be avoided if you make sure you're dotting your I's and crossing your T's.
Yep, definitely. Something else that I've noticed recently, Travis, especially with the growth and popularity of infographics, sometimes I will go to a blog post and find an infographic, and I will actually see they will say, "Hey, feel free to embed this on your blog post," and they'll actually give the embed code for the infographic. So is that basically permission to use that?
Yeah, that is, and you can give away whatever rights as the person who owns the copyright rights. You can do what you want with them, including give them away. And so I've seen that as well. And YouTube's an interesting animal because you have to be careful how you set up your settings when you're downloading some of the videos, because sometimes it says you have to allow people to embed the video so that they can take it somewhere else and embed it. So it's interesting how all these things are working. But certainly if somebody says you can take it, what I would do and this is probably do what I say and not what I do. I would print off that page and put it in a file somewhere or save it onto your computer system somewhere so that you can show, I uploaded the image on or about this date. Here's what the website said at the time. Therefore, I had permission and authority to do this.
And that permission probably it's probably a good practice. Like if I see Seth Godin wrote a great blog post and I want to do a post where I quote him and then comment, if I get his permission, then if I get his permission, if I have an email from him saying, "Yes, Rachel, you may use this content," am I good? Am I on the right side of the fence?
Yes, you certainly are. And unless you're dealing with large portions of high famous or very expensive content, that's probably enough. If I wanted to, if you wanted to use a portion of my blog, and I would tell you, I don't know what my numbers are actually, but they're not enough for you to go through a lawyer and get a licensing agreement and all that stuff. And so to get an email from me is perfectly fine. Once you start dealing with the media companies and whatnot, you may want to make it a little more formal. But at that level, just an email, saving it in the file is a good practice.
Okay, great. Well, Travis, you shared a wealth of good information with us today, including letting us know about those gray areas to which there is no cut and dried answer. So if one were to follow you and learn more from you, where would they go?
Sure. So the blog that I've talked about, probably nonstop since I've been on this podcast, is emedialaw.com, where I write about different topics that affect internet marketing and media law. The Twitter is at Travis Crabtree, and then there's a eMedia Law Facebook page as well, where I put a lot of shorter things. That goes to my Twitter feed as well. So a lot of shorter things where I just link to different articles of interest can be found on there too.
Wonderful. Well, thank you again, Travis, and look forward to inviting you back again when we have more questions.
All right. I look forward to it. Thanks, Rachel.
Thanks a lot.
Many thanks again to our special guest, Travis Crabtree, for joining us today to talk a little bit about intellectual property and the protection of online content. I do have a point of clarification that Travis provided me with. He was talking about the statutory damages that range from $750, and the upper limit of that is actually $30,000. He did not have that upper limit at his fingertips while we were chatting, but he was kind enough to clarify after the fact. So those statutory damages can range from $750 to $30,000. Again, you can find Travis's blog at emedialaw.com. No punctuation, just emedialaw.com. And you can find him on Twitter at Travis Crabtree. If you have any questions or want to add to the conversation, I would love to hear from you, and I will give that contact info at the end of the podcast. Now it's time for our content marketing tip of the week. So what do you do if you love to create content and have tons of ideas, but you just hate to write? I talk to a lot of people who are just brimming with brilliant ideas that they could be sharing about their area of expertise, but they aren't blogging, they aren't creating ebooks, they aren't putting together articles for third-party sites because, as they tell me, I just hate to write. So one thing, well, of course, one option you would have would be hiring Resonance to create your content for you. Be happy to talk to you about that. But another option is to speak your content and have a transcriber put it in writing. And a lot of people who tell me they hate to write are just brilliant oral communicators. They're great in sales, they're great on the phone, they're great up in front of an audience. It's just that sitting down to write that is the sticking point for them. So what you can do is, if you have an idea for a blog post or even an ebook or a more substantial book, what you can do is just grab the voice recorder app on your phone or your computer, or if you have a standalone dictating machine, whatever technology you had to capture your voice, just record what you want to say in that blog post, what you want to say in that ebook, etc. And then you can send it to a transcriber who will get it all down for you in writing. And yes, the web is full of professional transcribers who offer their services for audio as well as for video. And you can find someone who is well recommended and very good and very reliable who will get that content in writing. So then you have some raw content that is in writing, and then it's just a matter of editing, formatting it, maybe putting in hyperlinks. You, of course, want to add a terrific title and some subheads, and before you know it, your brand new content is ready to make an impression. Okay, campers, that is it for me today. I hope you've enjoyed this episode of the Content Marketing Podcast. I want to say thanks again to our guest, Travis Crabtree. Again, the URL for his blog is emedialaw.com, and you can also follow him on Twitter at Travis Crabtree. If you like what you've heard today, please feel free to subscribe on iTunes or Stitcher or via our RSS feed. And if you really like what you've heard, please leave us a quick review on iTunes. I would greatly appreciate that. Also, if you want to learn more about content marketing, I invite you to check out our website, resonancecontent.com, where you'll find our blog as well as links to all of our social media pages. As always, I like to leave you with a quote, and today's comes from Anonymous. I found this great quote on the web, and for the life of me, I cannot track it down to a source. So if the person is listening who originally said this, I will attribute it to you. Let me know. So this person, whoever he or she may be, once said, quote, "The worst thing you write is better than the best thing you did not write," unquote. Again, this is Rachel Parker with Resonance Content Marketing. Thank you again for listening, and we will see you again next week. Take care.